Hello, everybody. Martin Radner here from Radner Law Group, bringing you trial analysis. Today, we're going to be discussing the Taylor Schabusiness trial, which just concluded. There was 2 phases to this trial, which we're going to jump into very soon. But first, please like and subscribe to this channel. We've been thankfully growing. We are still in our infancy, but we still need to continue growing in order for me to continue bringing this trial analysis. So, thanks to all those who have subscribed, and we'll share this video. We appreciate it, and let's jump right into it. So, there was 2 phases to this trial. And why is that? The reason is that in many jurisdictions, the first thing that you've got to do as a criminal defense attorney is you've got to figure out what is our defense going to be in this case. Are we going to have a good alibi? We're going to say that we were not there. So what's the alibi? What's your defense going to be when you're preparing for this trial? And you have to choose one. So you can either say, I didn't commit the crime, and this is the reason why I didn't commit the crime. You can't prove that I was there. I had evidence that I was in another place, or you can't put the gun in my hands, or maybe I was there. But the point is that I did not commit the crime. The other defense that you can say is that I did commit the crime, but I was mentally insane when I did, and since I was so insane that when I did, it doesn't make sense that I should be held responsible for my crimes, and therefore it's better to lock me up in a psychiatric ward and let them figure out how to treat me. So those are the 2 defenses. Do you say that I did not commit the crime? Or number 2, I did commit the crime, but I was mentally insane. So you've got to pick, generally speaking, you got to pick what is our defense going to be. And that's what you got to figure out with your client, what your defense is going to be. Now, in Wisconsin, you can actually choose both. You can say, number 1, I didn't commit the crime. Number 2, even if I did commit the crime, I was mentally insane when I did. So how, as an attorney, are you supposed to approach when you are able to actually argue both of these defenses? Number 1, I didn't commit the crime. Number 2, even if I did, then I was insane when I did it. It sounds like they're contradicting, and they are. They're contrary to each other. So as an attorney, how are you going to deal with this? So one of the things that you have to be thinking as you're going through this analysis is that, well, how many juries are there? If there's going to be 2 separate juries, one jury is going to decide whether you committed the crime. So then it makes sense. Okay, well, in every single case, I'm going to say I didn't commit the crime. And then we'll go to a jury. That jury will decide, okay, I did commit the crime. Okay, now we go to a second jury of different people, made up of different people, and that jury will now decide fresh. They'll see me fresh, they'll see my client fresh, and they'll say, okay, we're admitting that she committed the crime, but she was insane when she did it, and therefore she can't be held responsible for the crime. So if there's 2 juries, then I would think you always may as well argue both arguments. Now, the problem here is that in Wisconsin, it's, even though you can argue both defenses, but the problem is that you're stuck with one jury. So the same jury that's hearing the defense attorney saying and arguing that his client did not commit the crime, and if they find against him, then the next day that attorney is going to be arguing, well, you're right, she did commit the crime, but she was mentally insane. It's so weak, as an attorney, and you lose so much credibility when you're with one jury. And one day you're arguing that she didn't commit the crime at all, and she had nothing to do with it. And then the next day you're saying, yeah, of course she committed the crime, and she was so mentally insane that she committed the crime and should not be held responsible for it. You just lose so much credibility with the jury. So if it's one jury, you got to really think, am I going to argue both of these arguments, both of these defenses in this case? Now, I can also understand if, let's say, the evidence is not that great, if the prosecution has not brought such a strong case, if there's no confession, if there's no fingerprints, if there's no DNA, if there's just a lot of guessing and circumstantial evidence, then I can understand, because you can look at the jury in this with a straight face and you can say, look, I don't believe my client committed the crime. I mean, they have so much suspect evidence and there's nothing clear in this case. I really don't believe that she committed the crime. Now, the next day, if they decide that she did commit the crime, you can say, look, you can honestly say, look, I don't believe that you got it right. Essentially, that's what you're telling the jury. Like, I don't believe that you got it right. But the jury can still understand you, right? And they can understand that, look, okay, he didn't believe it. We found against him. But now he's going to argue also that she was mentally insane when she committed the crime. But when the evidence is so clear, in this case, the evidence was just abundantly clear that she committed the crime. There was no question about it. I mean, she spent an hour and a half in negotiations, and not interrogations, saying that she committed the crime and giving them details exactly what she did and how she did it. It was just so clear that she committed the crime. I really wonder whether it benefited her, the fact that they went through phase 1 in the first place. And also, you have to remember that when you're forcing the prosecution, you're forcing the state to prove their case, there's much more leeway in what's allowed in as evidence. So for example, in this case, one of the things that was allowed in an evidence was certain pictures of this body. Now, just to give you a brief overview of the case in case you haven't learned about it yet, it is a very, very gruesome murder. She was essentially having intimate relations with her boyfriend, and during the act, she choked him to death, and then she cut him up into pieces. She dismembered him into a bunch of different pieces and put the pieces all over the place, and they put his head in one place and put his arm in another place, and actually shaved down his leg at one place. I mean, it was just completely and totally gruesome. And as a defense attorney, if you're defending this case, the last thing that you want the jury to see is pictures of this, right? Because it's bad enough that they have to hear about it, but they see pictures. I mean, that just, they're going to convict anybody who's sitting in that chair. So you don't want them, you want to limit the amount of evidence that goes to the jury, specifically pictures. And one of the questions in this case was, should certain pictures of his decapitated head get into evidence? And it was eventually admitted into evidence, because if you're arguing that she didn't commit the crime, well, they have to prove that, number one, how was this crime committed? Was he choked? Was he beheaded? Like, how did he die? So that's part of it. Cause and manner of death is part of the case, and therefore they can make an argument that this evidence should come in. Now, once the jury sees a picture, they can't unsee it. And again, it's one jury. So if you're going to argue phase one of this case and say she didn't commit the crime at all, well, then all this evidence is going to come in, and then the next day it's going to be a lot harder. Once the jury finds that she did commit the crime, the next day it's going to be a lot harder to convince the jury that she was mentally insane when she did this, because they already have these gruesome pictures and they're out for revenge. They want to destroy somebody, and your client happens to be sitting next to you. So I really, really question whether it was a smart tactic to have to go through two phases of this trial. Would it have been better if the defense attorney would have just said, what, she committed the crime. Let's not get any of those pictures in. At least it's a much stronger argument that those pictures are not relevant anymore. And the only question really relevant is, what was her state of mind when she committed the crime? I question whether that would have been, I think that would have been a better tactic, to go about in this case. Okay, so phase one was pretty obvious. There's not much to discuss. I mean, you can go back and look at the trial, but it was, patently obvious what happened there. She committed the crime, and the jury was out for a very, very short time before they came back and said, yeah, she committed the crime. She is guilty. And then the real trial of the real question and real trial, what this trial was about, was the second phase of this case, was whether she was mentally insane when she committed this crime. And for this, obviously, you're going to have experts on both sides opine whether she was mentally insane. So what they refer to is it's referred to as NGI. The plea is called NGI, not guilty for reasons of insanity, or not guilty for reasons of mental disease or defect. That's what you keep hearing in the trial. And so what's the burden in this case? Now, generally speaking, the burden in a criminal case is on the prosecution. The prosecution has to prove their case beyond a reasonable doubt. It's a very high burden, right? It's the highest burden that we know. They have to prove that this defendant committed the crime beyond a reasonable doubt. They have to prove all their elements beyond a reasonable doubt. But when there is a case like this, where there's already been a finding that the defendant committed the crime, so now the question is, well, the defense is arguing, well, you're right, she committed the crime, but she was insane. So now the burden shifts to the defendant. The defendant now has to prove that she was insane at the time that she committed this crime. So there's a shifting of the burden, which is why the defendant goes first now. It's like they switch places. But there's also the question is, what is the burden of proof? So like we discussed, the prosecution has to prove their case beyond a reasonable doubt. Well, what about in this case where the defendant is arguing that they were insane? How much do they have to prove that they were insane by? How much do they have to convince you by? So here again, with the Wisconsin statute, it's just a very interesting wording how they decided to word this. So the wording is that they have to prove to a reasonable certainty by the greater weight of the credible evidence. It's a very interesting bunch of legal words and terms mixed together. And the way that I understand this, and the way that I would tell the jury about this, the greater weight of credible evidence means more likely than not. Is it more likely that she was insane at the time that she committed the crime over not being insane at the time that she committed the crime? And now, how much did I convince you that? Are you reasonably certain by my evidence that I've presented to you that she was more likely than not mentally insane when she committed this crime. So it's a hard language that the statute, the legislature decided to put in there. They could have just said more likely than not, or just say greater weight of the credible evidence, and that's just the simple preponderance of the evidence, or more likely than not, the standard that we have in a bunch of other different cases. But they also threw in that they have to prove to a reasonable certainty. What's a reasonable certainty? So it's just interesting wording, and that's why you hear the attorneys talking about it. But essentially, I would just view this case as more likely than not. It's more likely than not she was mentally insane. So the burden is actually less on the defendant than it is, generally speaking, on the prosecutor in the prosecution of their case. So we basically, what did you have the trial? What was the second phase? What was the phase two of this trial about? It was about experts. And as we see from the defense's closing arguments, he says, well, this case was about the battle of the experts. Take a look.
This case is a battle of the experts. We have Dr. Seipel, we have Dr. Engine, and we have Dr. Leighton.
Now, he also mentions that the father testified that she already had mental problems from growing up in his house, and she always had these mental problems. And then you spoke about his expert, Dr. Leighton. Dr. Leighton testified that Taylor Schabusiness absolutely qualifies for the NGI plea. Take a look.
Now, as it relates to Dr. Leighton, she is of the opinion, to a reasonable degree of psychological certainty, she testified that Ms. Schabusiness, Taylor Schabusiness, qualifies for the NGI plea based on her diagnosis of a serious mental disorder.
So here you've got his expert, Dr. Leighton, testifying, yes, she does qualify for the NGI plea. So there you go. You have your case. You have the evidence of your case showing that she was mentally insane. She couldn't appreciate. Again, there's two different requirements. It's that she couldn't appreciate the wrongfulness of her action. I mean, she couldn't appreciate right from wrong. And number two is that she couldn't either that, or she couldn't conform. She wasn't physically able to conform herself to act within the requirements of the law. I mean, she had such a mental defect or disease that she, even if she knew right from wrong, but she couldn't control herself. She couldn't conform her actions to act within the requirements of the law. So that's what you have to prove when you're trying to prove this NGI plea, and that his expert, Dr. Leighton, the defendant's expert, Taylor Schabusiness' expert, said that, yeah, she does qualify this NGI plea. And another big part about this case was the following. The prosecution is going to be arguing in this case, or they did argue in this case, that the law in Wisconsin is the following. If she is mentally insane for mentally insane purposes, for mentally insane reasons, then she gets to qualify for the NGI plea. But what caused her to become mentally insane? If it's the drug usage, that at that specific time she took drugs. Now, the evidence is clear. She took meth. She took meth before committing this crime. So if the meth caused her to go insane temporarily and commit this crime, then you do not get the NGI plea. Okay, so even though she was 100% insane at the time that she committed the crime, but if what caused that was her voluntarily ingesting meth or injecting meth, so then she does not qualify for the NGI plea. And that makes sense because her own decisions, she chose to take this drug, which caused her to become insane and then caused her to do this act. That you should be responsible for. The only thing we're not going to hold you responsible for is things that are out of your control. Somebody was born with a mental disease or defect, or they had some other reason that they became mentally insane. And now they have to deal with the rest of their life in this state. So then we can't hold them responsible for their crimes. But if it's because of the meth, then she is out. So one of the arguments that the defense is making is that this Dr. Leighton, who did her evaluation and decided that she does qualify for the NGI plea, she was off of meth. Taylor Schabusiness was off of meth, off of all drugs for over a year before Dr. Leighton even saw her and conducted her interview and did her evaluation. So you see clearly that this has nothing to do with the meth. Take a look.
She also says and opines that Ms. Schabusiness continues to have prominent psychotic symptoms and has not used substances for at least 1 year.
So that was some very strong points on the defense's side, and then he also has to kind of discredit the prosecution's experts, witnesses. There's a forensic psychologist. So Dr. Engine was the one that did an NGI evaluation. There was two experts that the prosecution called. One of them was Dr. Engine. The other one was Dr. Seipel. Dr. Seipel just did not do the NGI. Did not do the NGI test. He did the competency test, which is two separate tests. As if you've seen this trial, there's whether she's competent to actually, participate in the trial, and number two is the NGI, is at the time of that the crime was committed, was she mentally insane? So Dr. Engine said no, she does not qualify for the NGI. She was on the prosecution side. So the defense attorney has to knock some holes, has to say how Dr. Engine was really not missing some information, things like that, and that's what he does say. He says that she didn't know about the civil order. There was a civil order that she was required to go to a psychiatric hospital. There was a civil order that she was required to take medicine, and Dr. Engine didn't know about that. Okay, so he does try to poke some holes into Dr. Engine. He also says that Dr. Engine is not as qualified as Dr. Lighton. Dr. Lighton has more experience, has been licensed longer, so that's also some points for his side. Then she says that, in his opinion, this is what the defense attorney is saying, in his opinion, her report, Dr. Engine's report, is stale because it was done 9 months ago, and it was done further before the trial than Dr. Lighton's report. Dr. Lighton was less time, meaning the trial happened closer in proximity to Dr. Lighton's evaluation report than it was with Dr. Engine's report. And that's what he's arguing. Well, it's 9 months old, it's stale, and we have more recent evaluation.
But she did meet with my client on October 21st of 2022 and had a 3-hour interview with my client. That's 9 months ago. It's a long time ago. I would argue and submit to you that her report is stale.
So the problem with that argument, and it's a really big problem. I don't know why he even argued this, because the NGI evaluation is to determine what was her state at the time that she committed the crime. And this is something that if you watch the cross-examination of Dr. Engine, she pointed out to him. She said he tried to tell her, well, isn't your report stale? It's been 9 months ago. And she responds, well, I think my report is less stale than Dr. Lighton's report, because the question here is, what was her state of mind at the time that she committed the crime? So the closer you get to the crime is better than the closer you get to trial. So it was a weak argument, and I question whether it was smart to bring up those arguments. Okay, so that was the case, and at the end of the day, the jury found that she certainly did not qualify for the NGI plea, and therefore, she does not get to get to go to a psychiatric hospital instead of going to prison. Now, when I was watching this, I felt like the defense attorney was just a little checked out. I just felt like he was didn't believe it. I just didn't feel like he was giving it his all. And part of the reason is that if you look at these experts, Dr. Lighton, if you look at some of their testimony, Dr. Lighton is years and years more experienced than these other two doctors. I mean, Dr. Seipel became licensed in 2022. Dr. Lighton was licensed in 1993. Okay, she has so much more experience than Dr. Seipel, and she has so much more experience than Dr. Engine. And he did mention, you're right, he mentioned that, she's more experienced. Don't just say she's more experienced and she has much better credentials. You've got to hammer that home. This isn't a battle of the experts, as he starts up saying, oh, this is a battle of the experts. Maybe that's what you're thinking in your mind, but to the jury, this is not a battle of the experts. Our expert is so much more experienced and knows so much more what she's doing than these other two experts. You've got to hammer that home to the jury and tell them, And I think that is true. Dr. Lighton is certainly much more experienced. She's conducted hundreds of NGI evaluations, and many, many times the jury has adopted her findings and found that the person was insane. So you've got to hammer it home. Don't just say, she's a little more experienced. This is a battle of experts. What are you supposed to do in the jury room? This is not a battle of the experts. Our expert kicks. Our expert is so much better. And yeah, he tried to poke some holes, but was just missing. If he didn't sound like he believed in it. But Dr. Lighton, I think, essentially is a better expert. I think she is. She is more experienced, and she knows what she's doing. And she said, Dr. Lighton, in all of her years of experience, she has not seen someone like Taylor Schabusiness. He didn't mention that. Imagine telling to the jury, this is a person, you want to say maybe she poked some holes in her report, and maybe she didn't follow exactly the guidelines, and maybe there's some questions about her. Dr. Lighton has been doing this for 32 years. She has not yet, this was her testimony under oath, she has not yet found anybody who was as messed up in the brain and mentally problematic as Taylor Schabusiness. That's what the jury has to hear. And think about it, when you're in the jury room and thinking, look, here's a doctor, okay, battle of the experts, whatever you want to call it. This doctor who's been doing these evaluations for 32 years hasn't found anybody like Taylor Schabusiness before. And now we're going to say as a jury that she's not doesn't qualify for the NGI plea. So you got to hammer that home much more. And I think that if he would have hammered the home, it could be that the jury would have actually paused a little bit more and said, maybe she does qualify for the NGI plea. And maybe she does know what she's talking about. She said very clearly she was not malingering. Part of the arguments were that, Dr. Engine and Dr. Seipel says that she was malingering and she was trying to fake. She was, lying on some of the questions or whatever that she asked. Dr. Lighton said, no, I saw her. I evaluated her. I know what the problem is. This is a doctor who's experienced in 32 years. She knows what she's seeing. She doesn't have to conduct all these 500 questions. She knows what she's seeing. She's been doing this for 32 years. So I think that if that would have been hammered home more, I think that there would have been a better chance that Taylor Schabusiness would have qualified for the NGI plea. Now, also, another thing that I think that the defense attorney could have brought up or should have brought up is that tell the jury, look at her during this trial. Anybody that would watch this trial, and they had the video on Taylor Schabusiness a lot throughout the trial, there's something very obviously wrong with her. And she's not on drugs, right? They're not giving her drugs in the jail. There's something very obviously mentally problematic with her. Look at her. Look at her faces. Look what she's doing. She just makes you uncomfortable. You know that there's something wrong with her. So tell the jury, you've been sitting here for the past few days. You've been observing my client. There's something mentally wrong with her. There just is. So you should realize that. And that should help you get over the burden that we have to prove. We got Dr. Lighton, and you're actually able to observe her over these past few days, and you see that there's something wrong with her. So that helps support the evidence that there's something seriously wrong with her. And last point that I think should have been made is that look at the details of this crime. This was such a gruesome and horrific crime. Dismembering somebody, you have to be completely 100% just evil, not human, to be able to do this to another person, especially somebody that she loved. She loved this person. She loved her boyfriend. She just was psychotic. And she did things to his body that was just completely ridiculous. And my argument to the jury would be, the prosecution is going to tell you that this is all because of the meth. How many times do we hear about somebody dismembering their lover because they're on meth? How many times do we hear about that? Never, right? Because no matter how much meth you take, unless you're completely, totally insane before that, if you have some major mental defect or disease, the meth is not going to make you do these crazy, ridiculous things, these gruesome, horrific dismembering of your lover. So that's another argument that could have been made to the jury, looking at what she did to her boyfriend, just looking at that and knowing. Use your common sense, right? You're allowed to use your common sense as a jury, knowing that this is not what happens in regular daily life. Even though there's who knows how many thousands of people on meth, we don't hear about people just dismembering each other when they're on meth. obviously this is not because of the meth. This is because she's psychotic, she has a real mental problem, and therefore she does qualify for the NGI. But these arguments weren't made, and I think that it could be if these arguments were made, there would have been a lot stronger case for the jury to find that she actually does qualify for the NGI, and it could be that could have been the correct verdict. Okay, so that is my analysis. Please, again, like and subscribe to this channel, and we are looking forward to continue to bring you more trial analysis.